Hi, and welcome again to One Big Thing, a KAC legislative update. This week's big thing is Senate Bill 66, which talks about substantial interests and the need for local government officials to recuse themselves from either debating or voting on matters that they have a substantial interest in. But the bigger issue is actually transparency. And so that's what I'm going to focus on. But first, a little bit about Senate Bill 66. As I mentioned, this bill would require local government officials to recuse themselves if they have a substantial interest in any sort of development that is greater than $250,000. Now, this is problematic because obviously county commissioners, registers of deeds, county planning and zoning officials may have some interest in lots of different things that come before the county simply because they also live within the county and they are part of that community. Those interests do not mean that they should not be able to vote on those matters. However, it does mean that these county officials should disclose those interests. We shouldn't get confused about KAC's opposition to Senate Bill 66 based on those things. KAC supports transparency and wants to make sure that county officials are disclosing when those interests exist and when there could be a potential conflict. KAC also encourages local officials to consider whether or not they should recuse themselves if the conflict is so great that they cannot weigh the merits of the issue outside their own personal interests. However, to put into state law to require that a local official recuse themselves if they have any sort of interest in a project that exceeds $250,000 would mean that local officials would not be able to vote on many items simply because they sit on various boards and committees or they work in the community, they own land within the community, and that may prevent them from being able to carry out their duties and represent their constituents. These are just some of the issues that we raised in front of the committee during the hearing on Senate Bill 66. But the greater issue is actually transparency. We've seen several bills come up this session that deal with transparency and a perceived lack of transparency from county officials. Many of this confusion actually stems from a misunderstanding on what is required under the law and what things are necessary to be heard in open meetings versus what things can be discussed in either outside of open meetings during an executive session or when they are discussed by staff and not by county commissioners outside of open meetings. There seems to be some confusion on those things within the public, but it is our duty as county officials to make sure that that confusion is alleviated by explaining during open meetings what things need to be discussed and what things cannot be discussed during outside of open meetings. It is our duty to make sure that the public understands those things so that there isn't confusion that then causes those individuals to contact their legislators to introduce legislation that may or may not address those issues. So we have to make sure that even though we are working to be transparent, that the public understands those things as opposed to just working to be transparent with a lack of understanding from the public because they don't know what is going on and what is required to be going on during these meetings. I would encourage all of our county officials to make sure that you're reviewing what's required in open meetings and in open records as well. And not only that you're reviewing that, but that you are discussing in the open meeting what is required and how you are adhering to the Open Meetings and Open Records Acts. That's all for today, but if you have questions about Senate Bill 66, other transparency issues, or any other legislation that's moving its way through the Kansas legislature, please just let us know. We will see you next week again on One Big Thing.